Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Let's turn briefly to the subject of Internet intermediaries, shields from liability, and takedown procedures. This subject arises because of a decision made by policymakers around the world back in the 1990s to shield certain types of people from liability based on the content of messages carried in their networks or the content of messages stored on their systems. The first most obvious example of this were internet service providers and telecommunications companies. The concerns expressed by those companies were this: we want to build an operational internet, but we, the internet service providers, cannot do that if we're going to face liability for, let's say, copyright infringement or defamation or criminal liability for distribution of obscenity based on our network. We don't have any way of understanding what's going across our network in a significant way. So shields were adopted. You can find the most accessible version of these probably in the European Union e-commerce directive, sections 12, 13, and 14. While shielding certain people from liability in the 1990s was widely thought of as a great idea, as time has moved on, the subject has become, increasingly contentious. And here we've seen the more recent adoption in the U.S. of the so-called FOSTA-SESTA legislation, which starts to chip away with major exceptions to these liability shields. There's also an ongoing debate about whether these types of shields should apply to social media platforms or search platforms. Now, the reason that I've included this stuff in CyBOK is primarily because it has spawned an entire business process of dealing with takedown requests. Takedown requests are requests sent to some sort of intermediary that says, it's come to my attention that infringing material is on one of your servers. Please get rid of it. Now, the reason that takedown requests are important is because they trigger a clock. If the receiving party does not take down offending content expeditiously, then they lose the benefit of their liability shield, and at that point, they might face liability for the content of what they have failed to remove. Now, bear in mind, not everybody is required to take down content. So in Europe, for example, someone who is an internet service provider, if someone writes a letter to an internet service provider and it says it's come to our attention that copyright infringing material is going across your network, well, of course it is. That seems to be inevitable. So under Article 12 of the e-commerce directive, for example, it's not a requirement for those types of people offering that type of service to take down or stop the movement of content. However, if you are a hosting services provider, as defined, then you do have that obligation. And similar provisions exist in U.S. copyright law, particularly with respect to hosting services. Although people like internet service providers are not required to monitor their core network for offending traffic on a minute-by-minute or day-by-day basis, they can still be ordered by a court or by some other arm of the state to block or filter traffic. In Britain, for example, there was a well-known case where rights owners were unable to get the courts in a place where a server was located to remove offending material from the server. They were claiming copyright infringement. A lot of that infringing material was entering the United Kingdom. Now, the reason for the difference is because copyright laws worked differently between the two places. British copyright law was more restrictive. So, being unable to influence the activities of the hosting organization, the rights owners actually asked the British court to send an order to the British internet service provider, the largest one in the country, and saying, please block access to that server. Now, a block like that is obviously not perfect, but the court felt, well, it's good enough for now. That's the most effective remedy for these folks. And that's what happened. There are obviously many more dramatic examples of sovereign states issuing orders to their internet service providers to block various types of content from time to time. So you might find those orders not necessarily coming from a court. They might come from a Ministry of Justice or a Home Office, or they might just be done by executive direction, depending on the country.